I've done seminars for about 10 or 15 years on the topic of lien and bond law. But I like this seminar a lot more because I think that it's an under-observed area of credit management practices, the credit document, the credit application. Lien and bond law is important, but it relies on you having a good credit document right out of the chute. All right? So a couple of years ago, we came up with the concept that, you know, we need to start simple, and we need to talk about the language that people need to have inside credit applications. Years back, I had, and I'm glad they're not here in this room, and I'm not going to tell tales of who they are. I've got several clients in the room, and I was just joking that these seminars are the only time I actually see my clients. I didn't remember what John looked like, and had never met Margaret Smith before. She was from Oregon. For 3 years we've worked together when she was at Lumber Products. So these are always a hoot to get together and actually meet face to face. But this grows out of a lunchtime presentation we did a couple of years ago. And we found that our experiences in representing clients on very fundamental credit application issues had told us there need to be changes here. There are things like consequential damages that you guys can stay away from for 10 words, 10 bits of magic language. But without those, one client suffered, well, their insurance company suffered, because we did the smart thing. We immediately tendered to a carrier a multi-million-dollar loss because consequential damages were not written out of their credit application. 10, 12, 15 words can save your company that much money. Now, it's crazy that that should be the case, that a few bits of words, when everybody knew what you were thinking and what you were talking about, but just reducing them to writing can make that much of a difference. But it does. Law, in that respect, is crazy. It really doesn't matter so much what you're thinking. It matters what you eventually wrote down. Now, with that said, the whole notion that you have to have a written contract to have enforceable contract rights, particularly in terms of credit application, not true. All right, 90%, if not 99%, of all the contracts that are formed in the world are oral agreements. They're not written down. All right, but a credit application is something you should have ready to wear, ready to go, and if it's not used, if it turns out that you just invoiced, you responded to purchase orders, okay, we can live with that situation on the back end. But the best way to help you is right here up front. Let's look at our materials for a second. Everybody's got a booklet that looks like this. If you don't have one, let us know. And
Jim, I need two.
2, okay. You go. Okay. If you would, turn to what appears as page 1. Credit application issues and enforcement. Dara, can we go about 200% on that and just maybe take a, how about that? Can people see that? Does that help you at all? Can you see it? Yes? No? All right. Why are you extending credit? What is the purpose of your credit application? All right? You have to think about your company. What is the reason your company is extending credit? Are you anticipating that you're going to get the money from a general contractor, from a builder? Are you anticipating that you're going to get it from your customer, but they just are having cash flow issues? What's the nature of it? Identify the kinds of materials you're talking about. Returnable goods versus final sales on credit. Are you an equipment company? Do you rent out equipment? Do you sell fixtures for restaurants, tires, things that are permanently affixed to a truck or something like that? Or is it a fixture into a restaurant that you could go back and get? Are we talking about maybe Uniform Commercial Code financing statement rights, or are we talking about lien and bond rights? Are we talking about something you expect to see back at the end of a rental period, or are we talking about something that you're never going to see again and in fact is going to be extinguished the next time it's used at a construction project? Point 2, are you anticipating lien and bond rights for improved property? Throughout today's 2-day conference, today and tomorrow's conference, there are a lot of lien and bond seminars that are available. Now those are, of course, a right to record a deed against improved real property if you helped to enhance its value by your labor or by your materials. Or is this, for instance, going to be a unit item that you could actually describe on a one-page financing statement that you record with the Secretary of State? The nature of your customer. What business are they in? Are they dependent upon project draws to make their credit payments? Know the cash flow situation of your customer. That's critical. Think bad outcomes first. The whole point of this is that you need this credit application to help you collect money on the back end. Now, you also want it on the front end to know whether or not this is the kind of customer who's going to have issues. Maybe you can help them put their house in order and they can become the best and most loyal customer you can possibly have. But it starts with getting a profile of them on the credit application. And use terms that reward good customers and scare off the bad ones. We like to say that about 70% of your future business is going to come from your existing customers. Okay? And that 90% of the problems that you have come from 10% of those customers. All right? And if there was some way you could figure out who the bad customers were and shut them out on the front end, not shut them out, but give them guidance on how they can put their house in order, or else maybe that there's another supplier that's just a better fit for them, that has a little bit looser credit requirements and is willing to take more risk than you at your company are able to do. The front versus the back of the credit application. All right, we all know what a credit application looks like. You've got one at your company. It's generally 2 pages, okay? With some rare circumstances, I see 1-page credit applications, all right? The first page is going to identify who this company is. The second, and it's going to have some trade references. And the second page, it's going to have some boilerplate and it's going to have a personal guarantee, all right? And that's how that works. Prioritize on your credit application. What do you want your customers to know about what you are expecting of them? Okay? Now we're going very broad brush here. We're being pretty artistic right now, okay? There's nothing on the canvas. So we're starting from ground up. Now a lot of you have credit applications that only get changed every 3 to 4 years, something like that, or longer. I'm suggesting to you that after this seminar, you take the materials back to your boss, or if you're the boss, that you take these materials and consider them and decide, could we make some improvements in our credit application right now? I guarantee you that every single one of you can improve your credit application in some respect. For NACM, I did a seminar a couple of years ago, a lunchtime seminar. We had, I think, about 50 participants from all over the country, and from Mexico, and from Canada. And they all turned in their credit applications ahead of time. The variety of these credit applications was fascinating. Some of them were 7 pages long. Some of them were 1 page long. Some of them hardly had anything on them at all and had no terms and said, the invoices will supply the terms. All right? So you guys are good at what you do, and there's all kinds of ways to do this, but I'm pretty comfortable with the universe of 2-page credit applications, and that's what I'm envisioning as we talk about this today. All right, what do you want them to know? You want them to know that there's penalties if you don't pay. We're going to get into those kinds of details in just a second. What do you need to know about the customer? You need full identifying information. If you've got a personal guarantor, you want their social security number. The general rule out there is that if you're dealing with a limited liability company or a corporation of 5 years or less in business, you want a personal guarantee. Anytime you get a personal guarantee, you want the spouse's signature as well. What's an LLC? I think we all know what an LLC is. But for our friends in Russia who are watching this on YouTube, and we get a lot of lookups on our website from Russia for some reason. I don't know why. We'll just explain that a limited liability company is a very simple document. It's a 1-page set of articles of organization that you file with the Secretary of State. And you'll have an operating agreement with 2 or more members where you decide how much each is supposed to contribute and how much each person is going to get in terms of payment or at dissolution of the limited liability company. Now, an important distinction between LLCs and corporations. Corporations have to have shareholder meetings, and they have to keep notes. They have to keep minutes of those shareholder meetings and actually keep them and have them available. It's harder to run a corporation than it is to run an LLC. And as a result, most of the corporate formations in Arizona the last 10, 20 years have been LLCs. They haven't been S-corps. They haven't been incorporated entities. When you see a corporation applying for credit, they're making more of a commitment to the integrity of their business entity as a legal structure than the members of a limited liability company are. All right? The purpose of an LLC was a recognition that, hey, most of the smaller businesses out there simply don't need to be troubled with the problems of having quarterly meetings, having officers, and all those kinds of things. What they're looking to do is to avoid personal liability and not go bankrupt because, say, a builder withheld funds from them. We love you builders, if any of you are here. No builders here? Okay, it's the builders who always send a cascade of non-payment down the chain and put the subs out of work, and then suppliers have to lien the project. So what else do we want? We want trade references, all right? If they've got a line of credit at another company, you want to know about it. You want to know how much of a line of credit they have there. You want to know if these guys are viable and should be inside your credit accounts. Current bank account numbers with maximum and minimum balances the last 30 days. You want their industry licenses. If they're in the construction industry and they need to be licensed to do what they do, you should have their license number every time on that credit application, because the Registrar of Contractors can drop a cease and desist order on any project that's got unlicensed subcontractors where they're required. All right? And that means that your client, your customer, could have payment issues. If it's an LLC, you want all the members of the LLC, a limited liability company. If it's a corporation, you want all the officers. Take the time to check and see on the Secretary of State's website, on the Corporation Commission website, if these people are what they say they are. Are they in good standing? Partly because you want their representations on the credit application to match reality. So as a credit manager, when you open up these accounts, you got to do a little online surfing, okay? You got to do your homework on these folks. You got to look up their license number, make sure it matches. You got to look up on the Corporations Commission website, make sure that company is who they say they are. Ron?
When you say you want to get all the officer signatures in the LLC, are you referring to the personal guarantees as well, or just on the credit application?
Okay, I'm not saying all the signatures. Ron is asking about signatures from the officers versus personal guarantors. So let me clarify what I was saying here. I don't need the signatures of all the members, and I don't need the signatures of all the officers, but I want to know who they are. Okay? I want to know, if I see 4 different last names as the officers of a corporation, okay, I know I have a corporation here that's a little bit more serious than if I see a husband and wife corporation and they're the only officers of it. Okay? Same thing with the members. I want to see different last names if possible. It's okay. You're still going to extend credit if you're seeing all the same names and it's a family-run business. Nothing against that. But I don't need those signatures. For personal guarantors, now that's different. And we're going to get to personal guarantees in a second, but we're going to talk about the importance of getting somebody with resources as the personal guarantor and getting their spouse to sign and making sure that you're getting both signatures, that spouses aren't signing for the other spouse. We're going to talk about that in a minute. Okay. You want to know the type of the company and the date of company formation. Again, my just general rule is that if this corporation is older than 5 years, I think it's reasonable not to request a personal guarantee. Now, these are different times. Okay, we are seeing some strong corporations who've been kind of bulwarks of their local communities and industries go under because of cash flow, because they haven't been able to get lines of credit. they get committed to 1 or 2 or 3 projects, and it's all about the cash flow on that project, and even the biggest company can go down at that point. And I'm not talking about just Arizona companies. Some of the, we've seen it, the biggest companies who are well-resourced and have a lot of inventory in this country can go down if they have a 90-day cash flow problem, or if a lender is just very unforgiving and calls a debt due. A right to run a credit report on sole proprietors or personal guarantors, either for credit extension decisions or collections purposes. You know, some of this information, yes. I'm sorry, I didn't get your name.
Johnny.
Johnny, that's right. My dad's name also. Go ahead. You're prettier than my dad.
Is there anything you have to do special to take care of Social Security numbers? There have been some people balking about giving them.
Yeah. Well, what you've got to do, you have a right to ask for them, and you have a right to not extend credit if they won't give them to you. All right? So it's not anything that's not permissible to ask for. But if you record a lien claim with a county recorder, if they'll check and see if there are Social Security numbers, and they'll kick it back to you and say, we're not recording this with that there. The clerks at the court, the judges, they do not like to see these Social Security numbers in Exhibit 1 to the lawsuit, which is frequently the credit application. So what you've got to do is protect that information, because if that information is trespassed on because of your office, then you have liability. All right?
So keep it off the computer system?
Yeah, I wouldn't. I mean, listen, if I'm you, I'm going to scan in the credit application, probably in PDF. The other thing is that a lot of companies now are entering the credit application information, you know, into their software, and it's spitting out on the other side, the credit application. They're taking the information over the phone, or they're doing it at the counter while the customer is standing in front of them. And so that's appearing in 2 places, on the hard copy printout of the credit application, but also in your system. I just wouldn't worry too much about that. I think if you have basic computer security at your office, then you're not going to have an issue with people getting a hold of those SS numbers. There's 2 reasons, you've got information here. First, it's for credit extension reasons, and the other is for collections reasons. One of the reasons we like that bank account information is so if we have to sue when we get a default judgment in roughly a month to 40 days, it's 20 days to file an answer to a complaint. If the complaint is filed and served in state, it takes a few more weeks after that to get a default judgment. You've got the information right there to garnish if you need to. All right? What terms are required to form a complete contract? I said before that people think everything's got to be written to have a complete contract. No. You can form an oral agreement, or you can take a napkin and write out certain terms of a contract, and that napkin is Exhibit A. It's absolutely an enforceable contract. First, you've got to identify the parties. Make sure you get the name of the parties right. And also, you need to really clearly understand who it is that you are in contract with. All right? Are you in contract with a trade name? If you're in contract with a trade name, then that trade name is not who you are in contract with. You are in contract with the holder of the trade name, which is either going to be a company or it's going to be an individual. All right? Now, there are distinctions between an individual's liability holding a trade name and an individual's liability as a personal guarantor. Okay? An individual who holds a trade name, say, John Smith, if he's married to Jane Smith is also liable for breach of contract because those business incomes are presumptively community property in Arizona and in California, I believe also in Nevada. And by the same token, the flip side of that is that the business liabilities, the breach of contract, that's the responsibility of the community. They entered into that contract in order to make money for that marital community. But for personal guarantees, in Arizona, you have to have both spouses sign it. Okay? So know who your contracting party is. Know whether it's a corporation, a sole proprietorship, an LLC. Is it a trade name that is owned by someone else? If so, make sure you get the underlying owner, the DBA. Okay, if it's John Smith, DBA Smith Painting, you've got a person.
Excuse me.
Yeah.
Credit applications. Oftentimes, we receive credit applications from large corporations that we have no problem extending credit to. But our credit application is also our credit agreement, right? And a lot of times, you'll get signatures on the credit apps that are often, the title's office manager, payables clerk, things like that. Is that, I mean, they're not really business signers, right? So is that going to hinder you if you need to go after them later? That person may not work there anymore.
Yeah. Well, again, this goes to who your customer is. Okay, if this is a corporation, then any authorized representative of the corporation can adhere the corporation to the credit terms. Okay, but that person's got to be an authorized representative. If that controller, if the office manager was authorized at the time to sign the credit application, I don't care if they're gone at the time of the default on the credit application, just as long as they were authorized at that time. With that said, you know, most corporations, you really want to get somebody who had unquestionable authority to enter into the credit agreement at the time.
Yeah, because how do you really know if they are authorized?
Well, it depends who's, you know, controlling the gauntlet that this is all running through, okay? Is it a credit manager? Is the sales rep getting to get signatures on this and make these decisions? Let's say it's you, you're the credit manager, you've got to ask questions. And you've got to ask that question. And if you're not in a comfort zone that that office manager is empowered to bind the applicant to the credit application, you've got to go up higher in the chain of command and locate that person. If they're an officer of the company, the courts will take almost judicial notice that that person is empowered to adhere the credit applicant to the terms. But you know, if it's just a standard frontline employee, you know, good luck. Now, there's such a thing as affirmation of debt. We'll be right there, which is if a frontline employee signs the credit agreement and they weren't really authorized to do that, but then the corporation goes ahead and buys goods from your company and pays for them, and this relationship is established and goes on for years, they've waived the right to contend that this person didn't have the right to bind the company to the credit application. The court's going to find that, in all reasonability, certain waivers occurred, time has passed, that objection's gone. I didn't get your name, I forget.
Barbara.
Barbara, what's your question?
We have fillable electronic credit applications, and so often they're emailed or faxed back, and so they're not really signed. I mean, they type in the name, but they're emailed back. Should we say something that shows that they emailed it back to us, or is that not good?
Okay. Well, in Arizona, we have an electronic signature statute. Okay?
I haven't done that.
What's that?
I don't see an electronic signature.
Right. But an email can constitute an electronic signature. So if what you're getting back is an unsigned credit application with a cover email transmitting it saying, here's your credit application, and it's from Bob Smith, print off the email, staple it to the credit application, and put it in the file. Now, is that the best way to do it? No. I'm not happy with that, and I would rather see them type out their signature on the credit application and put /s/ or electronic signature, put ES in between a couple of slashes, or send a cover email saying, this email constitutes an electronic signature of the credit application, and you keep the two together. I would like to see everything together on one document, and frankly, I don't understand why they couldn't print it off, sign it, and fax it to you or mail it to you. But at minimum, you want that typed out, and you want /elect sig/.
Okay, and then save so they're going to show that it was in the date.
Well, if you've got it all in one place on the credit application, that's not necessary. If you've got them typing out their name and some indicia of a /s/ or /es/ then you don't need that cover email. But if they didn't write anything in the signature line at all and just sent it back to you and said, we're good to go, something indicating approval of the contract terms, then print off that email and keep the two together.
Is Arizona the only one that does that?
Excuse me?
Is Arizona the only one that does that?
That has an electronic signature? Most states have electronic signature
Is that okay
statutes.
For every state to have, if they just put an email with it?
Yeah, I mean, Arizona isn't that specific as to whether or not you can do a cover email and that. Arizona, either the statute or the appellate decisions that have interpreted it have said that emails constitute signatures. There's sometimes I formalize it up. If I'm making an agreement with another attorney, I'll type out my name and I'll put it at a larger font size, and I'll put /s/ or I'll put electronic signature, and then they know there's no fooling around. But usually just the email itself from a known email address for that person, and you have reason to believe they were in control of the ISP, the mailbox at the time, that's enough. And we had one back there. Didn't you have a question? No? Yes? No? Okay. What time are we at? Right. 3:15. Okay, we are, what do we have, an hour? Okay. Well, let's keep going. I want to just have you walk out of here and have you guys know what generally it takes dumb law students like me a whole semester to figure out, which is what's in a contract. So let's just read it aloud again. Identity of the parties, identification of the goods to be sold or rented, the price terms, the time per performance, and miscellaneous if you want it. This doesn't have to be in here, but you can include it: jurisdiction and venue, right to attorney's fees. So identity of the parties, identity of the subject of the contract, the price terms, and price doesn't have to be dollars. It can be exchanges of labor. It can be barter. It's the consideration is the word actually, but that's not one that everyone's familiar with. And then the time for performance. If you got those things on the cocktail napkin, you have a contract. Your company's necessary information should be in there, all company identifying information, your internal account number, your area to note approval or decline of the credit, your spending limits, the date of the approval, the office for approving or declining credit, and its important choice for venue and jurisdiction for lawsuits regarding the credit application, and a space to reflect name changes or change of information related to personal guarantees. Listen, I'm going to talk about venue and jurisdiction clauses in credit applications in a minute, but one of the reasons that you want to indicate which office approved the credit application is because if there's not a venue and jurisdiction clause, then that little stamp saying Glendale office, Mesa office, that's going to tell me that jurisdiction and venue is clearly in Maricopa County if we want to choose to make it there. All right? Reverse side boilerplate, these are remedies on non-payment. Okay, remedies on non-payment. What's boilerplate? It's got to be some like 1920s term on those little metal plates. They probably hammered on a boiler. All right, but it's the stuff that no one reads. Nobody reads it. All right, I have to. It's in about 6-point font. It takes an hour, hour and a half to read it. All the terms conflict with each other. And you go, how many different people wrote this without reading the other portions? But that's what boilerplate is. On the reverse side where that boilerplate is, and now I'm thinking again, just that standard 2-page credit application with 12-point, 13-point font on both sides. Reasonable, easy to read with the expectation that everything in there is going to be read. On the back side, that's where you'll have choice of law and jurisdiction, saying in the event of suit, Maricopa County, Arizona will be at the seller's discretion, the appropriate choice for jurisdiction and venue, and for choice of law, or in the county of the place of sale. And that's at the seller's discretion. That should really be your choice of law and venue jurisdiction. Right to obtain credit reports on individual debtors, including personal guarantors. Look, if this is a DBA, if this is otherwise known as a sole proprietorship, I shouldn't say that. Not all DBAs are sole proprietorships, but really most are. There's very few corporations I run into that are running in a different name. So you want a personal guarantee if you've got a younger company, or if it's a sole proprietorship, you want to run a credit report. That's the reality. And you want to have a right to run a credit report with particular language in that document. Rights of reentry and repossession. If you're selling fixtures, you want to have a right to re-enter and get those fixtures. Now, if you sold to a TI, to a tenant improvement, that may be harder. They may only waive their objection, and the actual owner of the property may not have waived theirs. And then you've got some miscellaneous stuff that you would put in there: finance charges, rates of interest on judgments, various other things. Relationship of credit application to mechanics and materialman's liens. We included in this document some brief summaries on what a lien claim is, on what a bond claim is, and the point of the credit application is that in either instance, whether under Arizona state lien laws, Arizona state bond laws, which are little Miller Act laws, or federal Miller Act, when you sell to a government, a federal agency, a federal project, the agency owning, say, the project, you have a bond that the general contractor has to put out there for your payment opportunities if there's a breach of contract by your customer. All of those statutes require that you have an enforceable contract between you and your customer. So it all starts at the credit application. Relationship of credit application to payment bonds, well, I really already talked about that. And there's different payment bond seminars that are going on, including one that I'm teaching tomorrow. So all you need to know there is that you can't make a claim against a federal payment bond on a federal project unless you have an enforceable contract. Okay, here's the gold. Common problems in credit applications. Avoid this stuff. All right? Information about your customer. The credit application ought to tell you who your customer is. In the event of default, help you to find them, get a judgment, and collect it. So in addition to the information about the identity and creditworthiness of the company and its principals, your credit application should ask for other names the company is known by. Okay, the corporation is applying for credit this time, but do they have a trade name? If so, what is that trade name? And if you're trying to establish successor liability interest, if a year from now that corporation's gone, but there's that trade name out there doing the exact same kind of business with the same people and they incorporated it, then you've got a pretty good claim to sue that successor. All right? You want the bank name. We've said that. You want the marital status of the principals, social security numbers, dates of birth. You want these for a couple of reasons on the dates of birth. All right? First of all, you want to know how old these people are you're dealing with, because maybe the sales rep is gathering the information. You're the credit manager. You never meet the applicant. If this person's 27 years old, maybe you want the parents to personally guarantee the debt. The other thing is, when you get a judgment, you're not going to... This is how judgment debtor exams work. Okay, we have a judgment. We go and we serve the representative of the company or the personal guarantor that we have a judgment against. They come down to the courthouse. The judge comes out. We're in a room essentially, very much like this. And the judge swears in the judgment debtors. And they go out into the courtroom hallways and sit down on benches, and the lawyers ask them questions. Sometimes they go across the street to the law library. Sometimes they go to Starbucks. Okay? Sometimes, like I had a situation a couple of weeks ago where you go up to the top floor. I found an empty courtroom. In 10 minutes, we were back down there because the judgment debtor wouldn't cooperate with questions. In that case, you put them on the stand, and the judge participates while you ask the questions. But if they don't show up, you can get a civil arrest warrant, which is the most innocuous penalty known to law enforcement. A civil arrest warrant says that if the judgment debtor is pulled over for a routine traffic stop, they'll run warrants. If they see that there is an outstanding warrant for a judgment debtor exam, they'll bring him down to jail, wait a few hours where they try to call you, and you can come down and ask questions. A couple of things you need to know about that. Number one, it never happens, and there's no second thing. All right? So the civil arrest warrants are a waste of time, but they will make your boss feel pretty good. The vice president comes along and says, what happened on that? Did they show up? No, but we got a civil arrest warrant. Oh, well, that'll show them. So anyway, to get that, you need the date of birth, because the commissioner or the judge is going to ask for the date of birth. You'll call up the credit manager and they go, you know, I don't have it, and let me get back to you on that. And you say to the judge, Your Honor, we're going to give that to you in another day or so. Yeah. And then you never talk again. Okay, that's how it goes. Collecting judgments is a little disheartening in this environment because the way I collect judgments is not with a hammer. Okay, I collect judgments kind of with surgical tools instead. I want to keep that customer of my client afloat and help them work through this so that my client gets paid. All right, that's really my goal. I don't, and most lawyers, frankly, are that way because, you know, practicality rules. You know, I tell judgment debtors and I tell defendants in general that if you owe my client a little bit of money, you're their enemy. If you owe them a lot of money, they are your best friend because the only way they're going to get paid is if they work with you. Okay, let's look at some of these, the statement of terms. The credit application is your contract with your customer. It should state the essential terms of that contract, including the time for payment, the interest rate that will apply to unpaid balances. So you got to have that in there. Per annum is per year, per diem is per day. Legal terms. The credit application should have at least 2 legal clauses. You've already heard me say this about 3 times. So on venue and jurisdiction, it's your opportunity to control which court determines a dispute. All right? If you don't designate a venue, it'll be the county in which the transaction occurred or the customer is located. The choice of law. You want to choose what state's law applies to the dispute. If you forget to do that, then the jurisdiction and venue where the court is, that state's law will control. Attorney's fees, you want to say that the prevailing party gets attorney's fees at the end of any lawsuit. You can say that the seller gets their attorney's fees, but and call it a unilateral right. It works one way only, but the courts will almost invariably read that as a bilateral right, meaning the prevailing party gets attorney's fees. In Arizona, we have a fee statute called ARS 12341.01A, and that's a subsection that deals specifically with the prevailing party in a contract litigation gets a reasonable award of attorney's fees. Any attorney that tells you that, oh, don't worry about paying me, this is a contract lawsuit, the defendant's going to have to pay. Okay, just smile, drink their coffee, eat their donuts, back out slowly, nod, you'll be in touch with them, get in your car and speed away. Okay, there's several things going on there. First of all, either this attorney has no grasp of reality or they're defrauding you, because the reality is that no judge is going to make a 100% award of attorney's fees from the other party unless there was bad conduct involved and it comes in the form of a sanction, in addition to, say, the contract rights. Usually they make a reasonable award of attorney's fees, which is, say, 50 to 75% of the attorney's fees actually incurred. We did a fee application recently where we called out the amount of attorney's fees and we said, all of this is reasonable. It's all documented through our time entries. But here's what we're going to do. We think 75% of that amount is presumptively reasonable. So we're going to ask you, the judge, to enter just that much as the award. We did that because, first of all, I think it brings you great credibility to give the judge an easy way out on that. And also, I think it makes it a lot more likely that you're going to get that kind of award if you give them an easy way out. Personal guarantees. 2 problems in personal guarantees. First of all, when you don't clearly designate the guarantee, it ought to be clear to whoever is signing the credit application that they're giving a personal guarantee. And I think the guarantee should be separate from the credit application to remove a doubt in that purpose. Now, there are there are suppliers, there are contracting parties who will use what's called a dual-use signature, that when you sign the credit application, unless you restrict the scope of your signature, you are also signing as a personal guarantor. Perfectly legal, perfectly enforceable. The credit applicant has a right to say, signing only as officer of the company and not personally. They can write marginalia out there and put their initials and their date. But I think first of all, it leaves you, the supplier, or the company supplying the labor or materials, whichever, it leaves you vulnerable to a judge saying, I don't like it. I don't think they knew what they were signing, and you got to have a meeting of the minds. And it's too ambiguous for me, so I'm canceling it out. In which case, you probably on the front end of this credit relationship could have gotten them to sign a personal guarantee, but now you don't have one. And the other thing is, it's a little bit about a fairness thing. You know, you want people to know what they're signing. And I know without question that there's a lot of people out there signing these dual-use credit agreements that had no idea that they were a personal credit applicant and guarantor as well. So I think, you know, I'm kind of a believer in karma. What goes around comes around. I think if you treat your customers well, and if you have sound ethical credit practices, which all of you have, I think that you're going to have a better relationship with those customers, and things are going to work out just a little better. You need to require the spouse's signature. Get it every time. Even if you're not sure, you know, if you're lending credit to somebody who's in a Midwestern state, an East Coast state, you don't know how their community property laws work, don't take the chance. Get their spouse's signature on there. Best practices. That's page 4. Okay, so best practices are where you really save some money. Then you really can be a hero. And if I had an opportunity to write someone's credit application from the very start, most of what I would have in here, half of it you just saw, the other half would be right here. And I would do a couple of things. Number one, I would keep the credit application fairly simple, okay? Because your invoices are going to supply the details of what you sold, what you rented out. It's going to have the price terms. If you sold a flat of paint, it's going to say what the paint was, and it's going to say how much for a 5-gallon drum, etc. Okay? You've got opportunities to fill in the gaps with your invoices. All right? The other reason I would keep it simple is that this is a learning moment for the customer. All right? And that matters for 2 reasons. Number one, if they know what they're getting into, they're more likely to stay current. And number 2, if they don't know what they're getting into, they're less likely to be reasonable upon default. And they're going to say, I just didn't know that I had to pay anything above the $5,000 monthly limit. It says $5,000 monthly credit limit, and when you come back and say, oh, no, that's for our use. Doesn't matter if we extend you more than $5,000 a month, you've got to pay the whole thing. If they don't understand those kinds of things on the front end, they're more likely to breach, and they're more likely to be unreasonable in how long they fight this out, believing they might have a valid claim. All right. Beyond the minimal information required in a credit application to form an enforceable contract, there's terms that you may use that are going to improve your credit advance experience and your customer's experience with your company. All right? Be certain. That's one of the reasons I like to have a simple credit application that chooses its fights, chooses its battlegrounds, and then make sure that those terms are particularly clear. First of all, limit the terms to the credit application and the invoices. No place else. I don't want to see, if a file comes into my office, I don't want to see correspondence that had a bunch of extra terms in it where you modified the agreement. No, don't do that. Reissue the credit application with new terms on it. But there's got to be a distinction between the puffery and the customer-friendly greetings in the initial letter welcoming them to the company and the credit application. All right? We all know what puffery is. You're going to have the best credit experience you ever had. Our copper, it's the best copper on earth. In fact, it's better than most planets' copper. I guess other planets have copper. But, you know, everybody knows that's just schmoozing, okay? And schmoozing is fine. But, you know, you've got to make certain that your schmoozing does not leak into your credit document, and make particular warranties, because it's not a long walk to go from assurances to legally enforceable warranties and guarantees of quality. All right? Integration clauses in a credit agreement. Oh, that sounds so neat. When you say, does that contract have an integration clause? No one knows what you're talking about. Most lawyers don't know what you're talking about, okay? But you sound smart, so I'm going to give you, that's your smart phrase for the day. Whether or not your contract has an integration clause. What's an integration clause? It's language that says that this integrates every other agreement that exists out there between the customer and the credit supplier as of the date this is signed, okay? So, if you had negotiations that led up to the execution of this credit document, those don't matter at the moment this is signed if there's an integration clause, because those are either reflected in the document and it's written out there, or they don't exist. They're not legally enforceable. So you can't sue later on if you're a customer who owes money and say, okay, here's my affidavit about what they told me at the time we had the negotiations. Now, this is called the parole evidence rule, that from an evidentiary standpoint, outside conversations are not permitted to come in except to explain ambiguities. Now, the flip side of that coin is that the courts view ambiguities in a contract as permitting outside interpretations of the contract whenever a phrase is reasonably susceptible of two different interpretations. Okay? That's why you got to make this thing very simple and very clean and not reasonably susceptible of two different terms. All right? 18% per annum, there's no way you can get confused on that. Okay? 30-day terms from the date of the invoice. You can't get confused on that. You got to focus on making sure those things are crystal clear. All right? By the way, to stop for a second, I'm a frustrated stand-up comedian, I guess, and before one of the seminars I had, you know, a crew with me, Dara and a couple of other people, and I was off in the corner scribbling, and they thought, you know, I was reading, I was very intent, and they thought, hey, he must be really working, coming up with some new things he's going to say here. And I got up and went, okay, so you all paid how much for this, you know, $175 or $35, whatever it is. We just want you to know there's a couple of additional fees that we're going to be charging today. The first is the chair fee. Now, if any of you want a chair, that's $15 extra, all right? And then there's the written materials. That's only $5 because they're not that good. But then there's the overhead fee. Now, you're welcome to just look at the materials and down at your desk, but if you want to look up at the projected materials, that's $25 extra. Now, there's a leaving early fee. We made a lot of money off that on our last seminar. That's $35. And I just went on, and mistake. Because this was an 8:30 seminar, and people were not awake, and for a couple of minutes they didn't know if I was joking or not, because I was very, very serious. Kind of like Willy Wonka at the end of the film, when he's tormenting that kid, and you realize he's kind of joking. And then to this day, I don't know if some people really understood that it was a joke. But anyway. And boy, if Willy Wonka and the Chocolate Factory doesn't tell you to beware of what you sign, you know, he waived all his rights when he went into that super bubble room, right? The fizzy lifting. Anybody know the? Okay. Back to this. All right, credit limits or anticipated monthly order levels. Now, I already explained that we want to avoid, you know, you may say $5,000 is it, sending out a message to the universe of my company. This customer does not get more than $5,000 worth of materials, or they can't have more than $5,000 in their aging at any one point in time, okay? Don't have the customer be in a position to use that against you and say, hey, your problem, you gave me more. Most judges get that. Some judges are coming straight from a criminal practice and aren't so familiar with civil contracts, okay? And so they might not understand that. Credit limit clauses and anticipated monthly order levels. So these are intended as a guide to the credit manager. When you're opening a credit line and not to exceed it, a court could agree, and so what do we do? The court, because as a result, the court could find the credit limit as the internal self-imposed limitation that it truly is, that you are entitled to disregard. You guys can extend credit beyond the $5,000 if you choose, and they're liable. But only if the court considers the parties, that's point 2 on page 4, to have waived the limit as a consequence of the customer placing orders that exceed the limit and the supplier granting those orders, i.e. an offer and acceptance. All right? The problem is that the integration clause might prevent that. All right? The contract itself is pretty clear. You got a $5,000 limit there, and so doing these side agreements as to how much can be extended each month could be a problem. So, how do you solve that? Number 1, don't use the clause at all. Don't have a monthly restriction on the credit application. You're saying, wait. You know, I don't want a sales rep or somebody at the front counter giving this person $17,000 in paint, right? Well, they should be logging on to that account at on their computer every time and seeing internally what that credit limit is. You can still have the credit limit inside your accounting information at your company, just not on the credit application. And they can even know what the credit limit is. You can tell them that we don't want to see you exceeding $5,000. But it's a far different thing for the documentation of that to be in your records as opposed to be on the credit application. I prefer this instead. These aren't too many words. Anticipated monthly orders, dollar value. That's 4 words and a dollar sign with a number. Okay? But what it doesn't do is it doesn't give the customer any rights to invoke that clause and say, you exceeded it, your problem. What it does do is it speaks code to your staff, to your company that, okay, these anticipated monthly orders, bang, that means we don't exceed that. Okay? So you're talking code inside. Estimated monthly purchase levels don't limit the supplier's right to extend credit above that amount, and they also don't excuse the customer from payment of the amounts that exceed that dollar amount. Waivers of liability. I'm sorry.
That note doesn't have to be included in the application, though, does it?
No, don't put that note in there. Well, you can. Let's read it aloud for a second, because I think that's why I wrote that originally. Note, estimated monthly purchase levels do not limit supplier's right to extend credit above the anticipated amount, or in such event, excuse customer from payment of amounts exceeding the anticipated monthly purchase amounts. You know what? When I originally wrote that for this, I actually was recommending that this go in the credit application. The problem is, I don't think you have room on the credit application. And the good news is, I don't think you need it as long as everybody on staff understands what anticipated monthly orders with the dollar sign means. Okay? Your choice. If you got the room, yes, put the note in the document. Waivers of liability. This is really important, okay? This is where you're making money for your company, this language. Sample language, and this is pretty much the best I could come up with. Seller expressly disavows, and customer expressly waives any and all claims for breach of express or implied warranty, including warranties of fitness for a particular purpose, merchantability, and any other common law or uniform commercial code warranties or other protections. Okay, you with me so far? Seller's disavowing and customer is waiving claims for breach of express or implied warranty, including warranties of fitness for a particular purpose. Hey, this paint didn't match the exterior surface that I was painting, facing Marina Del Rey. All right? Doesn't matter. That's a warranty of fitness for a particular purpose. It's your job to buy the paint that works with the exterior surface you're dealing with, not ours. All right? Merchantability. Hey, I wanted to resell this paint to my general contractor when it was left over at the project. He didn't want it. Tough. All right? We don't have warranties of merchantability. And any other common law or uniform commercial code warranties or other protections. The Uniform Commercial Code is a document yay thick. It's been picked up on by all the states around the United States and adopted with people changing a few words here and there. But for the most part, the Uniform Commercial Code is generally accepted as dealing with the sales of items. You want to waive those protections for the customer if you can get them to sign it. All right? The reason is because there are very nuanced limitations on the sale of goods, which require, in certain instances, your contract to be in writing, There are rules about whether or not you have to pay for transmittal of your product, whether it's free on board, all kinds of things that you just don't want to go into that universe. If you don't strike the Uniform Commercial Code protections for the customer, that big volume hitchhikes on your credit relationship. Okay? Continuing. Customers' rights against seller for breach of this credit agreement are limited to the purchase value of the materials. You can save yourself so much time and effort if you're able to say, okay, so let me get this straight. My copper, for some reason, didn't adhere to this rooftop. I don't represent any copper companies. And I don't even know if copper adheres. I don't know how copper works. Okay. But let's say you said it was supposed to adhere to the top of this building. It didn't adhere. And now they're suing me for $100,000 because it looks so terrible. And they lost future business because people drive by and they look at this rooftop and it looks terrible. So I paid $10,000 for this copper. I'm suing you for $100,000, which is what they're suing me for because now they've lost all this business as a result. If you have this language that customers' rights against seller for breach of this credit agreement are limited to the purchase value of the materials, all you can be liable for is $10,000. Okay? Customer expressly waives any and all claims for damages against seller, including incidental, consequential, special, or punitive damages, or damages for lost profits, negligence, or other tort claims. My 5-year-old son got up on this house when I was putting copper on it, and he ate the copper, and now he's sick. I'm sorry. Get out of here. That should be your response, okay? But more relevant in terms of the consequential damages are, hey, I worked for this builder for 20 years. I was planning on working them for 20 more. Your copper didn't adhere to the roof of this building, and as a result, I lost all this future business. I expected to make millions of dollars off the next 20 years from this builder. Gone now. They hate me. I'm suing you for that. You know what? It's possible that without this language in the contract restricting their rights, it's possible that that could be a foreseeable consequential damage. It is possible. Let me tell you how law works. There's two universes of law. There's criminal law, there's civil law. Okay? Civil law is all non-criminal law where the state is not a party and doesn't have the right to incarcerate you or fine you. The state doesn't have police powers against you, essentially. The state can be a party in civil litigation, don't get me wrong, and I've got one going with the government right now where they're on the other side, and that's a civil litigation. But on the civil side, okay, there's two kinds of law. There's contract law and there is tort law. Tort law is any civil remedy not sounding in contract, okay? Tort law is where somebody has a duty to you not to hit your car with their car. You're not in contract with them, but they've got a duty based in tort law. Don't ask me where the word tort came from. I don't know. It's all in that 1500s, 1400s area where they make a lot of movies, but nobody really knows what happened back then. That's where all the funny words come from. What you want to do is get rid of tort damages, and you want to limit the scope of contract damages. Here's the standard for contract damages. If you're in contract with someone and one of the parties breaches, the available damages are reasonably foreseeable and consequential. Consequential, reasonably foreseeable damages. You got to have understood that if this contract is breached, these kinds of damages are reasonably foreseeable, such as you get kicked off the job because the copper didn't adhere, and you had $50,000 left on your contract. 10% of that was going to be, markup and overhead. You lost all that as a result of this bad copper. It's reasonable to sue for that. All right? What you don't want are tort damages, for certain. Tort damages is anything proximately caused. Okay? If your red car hits a blue car, which hits a green car, which hits 20 other cars in a row, and a yellow car gets hit at the end, that yellow car can sue you. There's no way you could have foreseen that that yellow car was going to be there and get affected by this chain reaction that you caused. But it is proximately caused. So, and now you're a brain surgeon on this stuff, because now you're making distinctions on damages that not even a lot of lawyers completely understand. In this credit application, in the event of a lawsuit, you want to make sure no tort damages are allowed, meaning you don't want proximately caused damages, the universe of proximately caused damages, to be available in the event of a lawsuit. No tort damages. The second thing is you want to limit the scope of consequential, reasonably foreseeable contract damages. Okay? Now, what's the easy way to do this? Use the language I wrote here. I cut through this whole chase for you. Okay? Customer expressly waives any and all claims for damages against seller, including incidental, consequential, special, or punitive damages, or damages for lost profits, negligence, or other tort claims. You just got rid of all that. You just basically limited yourself to the value of the sale of your goods, and that's it. And they can't get you for anything else. Are they going to sign that at the front end of your credit relationship? If they want your product, yes. Because at the front end, the customer is never thinking lawsuit, all right? You are. Because you're in the business of thinking lawsuit. You're in the business of thinking credit extensions and credit applications and credit term enforcement, all right? This language that I just wrote here could keep your company in business. It could save your company millions of dollars. If one client had used it, it would have saved them that. All right? I could stop right there and just tell rabbit jokes, and you guys would have gotten your money's worth. In fact, so a rabbit walks into a bar. It's the last day before hunting season begins. He says, I want a beer, I'm celebrating. Bartender says, why? And Rabbit says, well, last day before hunting season, my last day of freedom. Bartender says, great, okay, here's a beer, it's on the house. Rabbit drinks it down, bartender takes out a shotgun and shoots him. Rabbit says, what gives? Hunting season doesn't start till tomorrow. Bartender says, can't you see the clock? You're a hair past midnight. Yeah. Okay, back to claims process. Sample language. Customer must inspect and state in writing any and all claims by customer for non-conforming product or non-delivered product within 10 days of delivery or agreed upon date of delivery. Let's do that again. Customer must inspect and state in writing any and all claims by customer for non-conforming product or non-delivered product within 10 days of delivery or agreed upon date of delivery. Okay. Look, you can shrink that down to 3 days. You're giving them 10 days here to open up the box of copper. I don't know what copper comes in, all right? But to check out their copper and see, hey, is this copper? Is it orange? Is it copper colored? It's green. It's oxidized. I don't want this. They've got to put that claim in writing and ship it back to you and make you aware of it. Submit the claim within 10 days. You want to shrink it to 3, go ahead, because frankly I think 3 is fine, but 10 is more than fine. Get rid of arbitration clauses. They limit your options. I think that arbitrators are not good at enforcing contract terms and waiver provisions. If you believe that you're going to prefer binding arbitration in certain circumstances, then you just put a clause in that gives you an option of requiring it. That clause goes like this. At seller's discretion, you're the seller, this is your discretion, your choice. The parties will use any of the following dispute resolution forums: non-binding mediation, appealable arbitration, or binding arbitration to be conducted according to the rules of AAA arbitration or state or federal court of competent jurisdiction in the county and the state. The selection of forum of dispute resolution is entirely the decision of the seller. Customer waives any right to jury trial regardless of the nature of customer's claims or defenses in any litigation between seller and customer. Get that waiver of a jury trial in there, please. Having a jury trial adds $50,000 at least to any lawsuit. Credit report.
Enforceable or just in Arizona?
What's that?
Contractually waiving your right to a jury trial?
Oh yeah, you can. Yeah, I'm not aware of any state where you can't waive your right to a jury trial. There's a lot of states.
You can waive the customer's right to a jury trial. Meaning he signs off on this, and then after the fact, they try to do a jury trial.
Yeah, well, then you bring
The judge determines that, yeah, you can go ahead and do it.
Well, I mean, the judge might not follow the law. There's nothing you can do if the judge doesn't follow the law. But yes, as a part of a contract, and it's not all that uncommon, the credit applicant can be made to waive a jury trial. And it's not unfair because, look, judges, in my opinion, are really pretty good at contract dispute litigation. They really are. They've generally seen every kind of contract at least once. All right? So I like them. I like the judge in that situation. I don't like arbitrators in that situation, particularly because arbitration too often is not, it's binding. It's not appealable. No. If we have a bad day in court and if there's enough money involved, and frequently enough money means over $50,000, over $75,000, certainly over $100,000, we want our rights of appeal. Everybody says, oh, no, it costs too much money to appeal. Not true. You can get in and out of the Court of Appeals and do a pretty competent job on the brief for $15,000. You absolutely can. You just have to be patient enough. And the way you do that, by the way, is by having the lawyers who represented you below in the trial court do the appeal. Because they've got all the stuff in Word, they know all the arguments, they can dump it into an appellate brief. It's just not that hard to do an appellate brief inexpensively if you've got a limited number of exhibits and a limited record on appeal, which in this kind of contract enforcement action you would. Okay? Credit reports. Don't be careful not to limit them to just business credit reports. You want personal credit reports if you're going to have personal guarantors. Sample language. The undersigned agrees that seller may obtain credit reports regarding customer and regarding any personal guarantors for purposes of evaluating a decision to extend credit, and at any time while customer has an unpaid credit account balance. In the event of late payments or delinquent balances, customer agrees that seller may provide credit information to third-party reporting agencies. You got to have that in there. You just got to have it. Request the customer's website address and email addresses for the owner and principal contacts at the customer's offices. This is kind of standard, even on fee agreements at my law firm now. We're now asking for a company's website, so we can take a look at who they are, what they're about. You want email addresses because so much of the communication you're going to have is by email. And also, the healthiest relationships that I find in business between suppliers, customers, is by email. People just don't have the time to hang around on the phone anymore, and the phone's very disruptive. The difference between taking a call now and taking it in 2 or 10 minutes is a big difference. Okay? And when you text people, when you email people information, and I don't like texting because I don't have a record of that, but I like emails because it lets them work it in to where they are, they get back to you, you have a record. I also like to keep emails in a string and not clip off prior messages, okay? Anytime somebody's clipping off prior messages, it always takes me back and go, what are they thinking? Why exactly are they doing that? Okay? You want the history of that communication so that, who knows, for purposes of litigation, it's just one print off and you've got them all there. Okay, inadvertent releases of personal guarantees. Don't let this happen. Sometimes the seller reaches a compromise with the obligor, and this can limit the liability of the guarantor. All right? The company who owes the money, you release them from all liability. That can act to release the personal guarantor from all liability as well. It's usually an express term, but it's frankly also an implied term of a personal guarantee that I'm only guaranteeing the debt that primary obligor owes to you. I'm not guaranteeing anything else. You release them, I'm gone. All right? Sample avoidance language. The personal guarantors agree to be held jointly and severally liable for payment of any delinquent account balance of customer, notwithstanding, which is a big word that means despite. Despite seller's obligation to prove the liability of the customer for any account balance as part of any claim against the personal guarantors, seller is not required to proceed first against customer before pursuing claims for payment against the guarantors. Okay? I don't have to go against the corporation first before I ask you, the personal guarantor, to make good on this personal guarantee. Is that fair in the universe of fairnesses? I don't know, but it's written down, and they should have read it when they signed this. Customer agrees that seller may release customer or any other guarantors from any and all liability on the account balance without having the effect of releasing remaining guarantors from any or all of the remaining obligation to pay the customer's account balance. No release, insolvency, or bankruptcy of customer or the other guarantors limits or in any way impairs seller's rights against the remaining guarantors. Now, no release, insolvency, or bankruptcy of the customer or the other guarantors limits or impairs the seller's rights against the remaining guarantors. Two of those words are very standard and reasonable. One is completely unexpected. Okay? No insolvency or bankruptcy of the customer or the other guarantors in the list of 4 guarantors limits the seller's rights against the remaining guarantors. Well, of course. That's the entire reason you have personal guarantees. The other people aren't available to pay. All right? But we added something in there. We said no release of customer or the other guarantors limits or in any way impairs the seller's rights against the remaining guarantors. All right? Here's the situation. You have a $30,000 account that's owed. All right? The primary obligor is going to pay you $15,000 if you will let them go. And then you've got all these other personal guarantors who can contribute the rest of the $15,000. It gives you the right to partially settle the primary obligation or with one of the personal guarantors and still have the right to pursue the others for the remaining balance. Okay? You need to clearly identify the personal guarantee. Use clear language identifying the section as containing a personal guarantee. Again, that's my preference. You can hide it in a dual use section that just says sign here and somewhere in the language that says I agree to be personally liable as well. Okay? I just don't like that you do that because first, courts are unpredictable, and second, customers will fight you until the end if they didn't believe at the time that they were signing as a personal guarantor. Okay? You need to establish the commercial nature of this transaction so that you don't run afoul of the Fair Credit Reporting Act, FCRA. All right? So when you pursue a sole proprietorship for collection of a commercial debt, that's not a FCRA debt. All right? Sample language. The customer agrees and represents that all purchases are for commercial, business, and non-personal purpose. And you want to make your terms in large enough typeface to read. That is why I hate boilerplate. Okay, we have 15 minutes left. What's that? Oh, right. Before I forget, because everybody launches out of here for some reason as soon as it's done. What's that about? Assignment of CEUs. This is a CEU. Control number 21068. CEU .015. Is that continuing education unit? Okay, so you're getting 0.15 continuing education units. The level of content is intermediate, and your control number is, again, 21068. There are 5,000 people on YouTube who just filled that in. And they're taking their association for a slow ride. Okay, let me tell you what else. In my dreams, 5,000 people are going to log onto this thing and view it. Yeah, as soon as this is posted, Dara's assignment for 1 week is going to be view, sign off, view, sign off, view, sign off. Okay, page 7 of this. I just want to show you the other materials that are in here, and then any questions you guys have got, because you're getting some really good materials that also go with this book. Frankly, this thing is a pretty awesome document that you have in front of you that about 15 years worth of attorney work have gone into producing this. And we've presented it, some of these materials at the National Congress for the National Association of Credit Managers. I have given too many lectures on this stuff to count. Page 7 is the Arizona Lien Payment Bond and Stop Notice Guidelines. This is what I suggest you do with this page. Xerox it off and either take it to a copy place, or if you've got a laminate machine at your office, make these. I'm sorry that I didn't bring enough of these for all you folks. Okay, that was completely my fault. But these laminates you can just post up on your wall. And when people call me up, just to remind myself sometimes, I'm picking these up and remembering okay, I've got 6 months. This is Arizona, I've got 6 months. This is in California where I've got half that time. Things like that. Turning the page to page 8, you've got a summary of Arizona mechanics and materials liens. Tell you exactly how it works in this state. Okay? It's just 2 pages there. Page 10, you've got a sample lien claim. And a lot of you folks aren't going to want to do it this way. You can fit the stuff basically on 1 page. In Arizona, you know, you've got to have some exhibits to it. You've got to have the contract, the proof of service of the 20-day notice, the 20-day notice, the affidavit of service, the 20-day notice. You've got to have a contract attached to it with the customer. California, you don't need those things. All right. Then going a little ways in, you've got our Arizona lien claim timelines. And this is something that's animated, actually. Oh, we've got it up there. Why don't you blow it up so everybody can take a look-see. This is a 1-year snapshot of a lien claim with the material supply happening at the beginning of the year and the last date to sue happening at the end of the year. And it looks really complicated, but if you realize that on the left side are the operational dates for 20-day notices, and then the dialogue you see going on here between the yellow and the blue blocks, that's talking about what happens if there's a notice of completion recorded, meaning your time to record your lien claim is cut in half. It's got a definition of a project completion. And it's got the timelines in Arizona for your last date to sue, which is always 6 months after the lien claim is recorded. All right. Continuing on in your materials, you've got at page 15, you've got payment bonds. All right. Nice payment bond summary. And we've even got some sample payment bonds in there. Do we have the timeline for payment bonds in here, Dara? Yeah, we do. We do. If you keep going through this, you'll see at page 21 a sample 90-day letter on these state and federal projects. Folks, you know, this isn't hard. You can read this and type this up yourself. It's just got to be served within 90 days in Arizona and under the Federal Miller Act, actually received. Okay? If you keep going to page 23, this is our Federal Miller Act payment bond deadlines. And our media company is just excited because we've got some colorful things here and moving objects, and this is just a gold mine. Or a copper mine. Let's stay with the theme. Stay on target. This is on federal projects. Again, these are very simple. When you've got a bonded project, a public project, this is where you want to be. Payment is just so much more certain because the general contractor is required by law to post a payment bond. And you can see the first day materials are supplied over on January 1 at the very end. And here we trickle into February 1 of the next year for the last day to file suit because it's 1 year after your last supply of materials. All right, so that tells you how that works. Then behind that, we've actually got the Arizona public project bond deadlines as well. A little more complicated at the local level. Again, 1 year snapshot, and it shows you that on January 1, you supplied some paint to a project towards the end of the project. Your 20-day notice is still required in Arizona, not at the federal level. And your last day to sue is going to be 1 year from the last date materials are supplied. On a federal project, the last day you can file suit on that payment bond is 1 year after the last date you supplied materials. Same thing for Arizona and for federal. The thing you need to know about Arizona on projects that involve, on public projects that involve bonds, is that you've got to do your 20-day preliminary notice. That single sheet of paper that I'm sure you guys are up to your eyeballs with examples of in this 2-day conference. Okay? I also have some materials back here, your rights to recover attorney's fees. Again, that parking lot you just squealed your tires on, peeling out because that lawyer said you were going to recover your attorney's fees for sure. Don't worry about paying him. Hey, the other thing that lawyer didn't tell you is that he's going to be sending those invoices to you every 30 days and wanting you to pay them and go, oh, well, don't worry, you'll be reimbursed at the end. Well, by the way, you might lose, in which case you owe the other side, they're at reasonable attorney's fees. And the other thing is they might go out of business. But guess what? The whole reason they're not paying you is probably because they don't have the money. So surprise, they probably don't have the money to pay your fees either at the end of the litigation. Okay? But nevertheless, that attorney was right that there are bases to recover attorney's fees in Arizona for any contract. Remember I said Arizona ARS 12340-101A? It says in any contested action arising out of a contract, express or implied, the court may award the successful party reasonable attorney's fees. May's gone away. The court will award attorney's fees to the winner, but the reasonable attorney's fees, that pretty much is 65% to 75%. That's what that means. That's what, you know, I find. And it can go down to 50%. Then there's a prompt payment statute. You can get your fees awarded if they didn't pay you if you complied with the statute's notice requirements. Contractor's license bond, stop work notices, and lien bond and UCC remedies. As a part of a mechanics lien, you're entitled to recover your attorney's fees. As a part of payment bonds, the Federal Miller Act will give you your attorney's fees if your contract with the customer says you should get them. So that's why you want that attorney's fees clause in there, because under the Federal Miller Act, it absorbs, it pulls right up the terms out of your contract into the enforcement of their law. In Arizona, the prevailing party shall recover reasonable attorney's fees. And for private payment bonds, a really big project, the payment bond will be in the amount and form prescribed by ARS 34222B. All right, last thing, we gave you some really friendly stuff. We parted with some golden documents here, which is a promissory note. Listen, folks, anytime you're in a workout period on the back end, all right, the credit application served its purpose, you've got enforcement rights, and now they're going to pay you pursuant to a payment plan instead of being sued. At that point, it's important that you get them onto a promissory note or a payment plan that they sign and that you know they've breached it if they don't pay. Why? Because if you have a 6-month supply relationship to a project and to this customer, guess what? They're going to trot out every argument they can, including that we didn't send a purchase order for that, we never got those materials weren't any good, and you didn't have a clause in there on how to make a claim if they're non-performing goods. All right, if you get them signed up on a promissory note, all that goes away. The only thing that matters, particularly if you use this particular kind of note, all that matters is that they didn't make payment as provided for in this promissory note because they waived their defenses. Okay, so what I do is I get the customer to sign up for sometimes a multiple tiered payment plan. Get them with some low payments at the front end because they'll look ahead 90 days and go, oh, I can make those payments at least. And then they'll sign on, and they do make those payments. But then they just can't make the rest of the payments. At that point, you have their ink on a promissory note, and they've waived their rights to demand that you prove up the invoices, the delivery of the materials. That saves you days and days in trial or in front of an arbitrator. Okay, that's really to your benefit. It saves you a tremendous amount of attorney's fees if you get them signed up on this. Plus, just in case it sounds like I'm taking advantage of people, look, I saved them from being sued in that first 90-day period by getting them onto some kind of a payment plan. And it is always in the discretion of the client to negotiate another promissory note. We have language in the promissory note that says an instance of waiver of a default in one particular instance does not act as a waiver in any other instance, meaning we can take your payment late this time. It doesn't mean that we agreed you can pay late every other time. All right? A security agreement is the next document, and a security agreement just says, hey, as security for this promissory note, I'm pledging to you my house. I'm pledging to you my vehicle. I'm pledging to you this construction equipment. We're a lot more interested in a piece of construction equipment than we are in anybody's house, okay? Or in their truck, their company vehicle. Okay, the construction agreement has construction equipment has unique niche value that we can find a home for that. UCC financing statement, this is all it looks like. That's at page 34. You fill that out. There's some language, magic language down in section 4 that's where the game is. What's this cover? Does it cover all their receivables? Does it cover a particular fixture? I don't have that magic language in there. If you send me an email, I'll send you the magic language. I think my email address is here somewhere. Is it?
Cover page.
No, it's not.
No, it's not.
Huh. I wonder whose fault that is. OK. Here's what you do. The law firm website is there. You just click on and go to my page, and you can send me an email. And if you want the magic language to put in point 4, I'll email that to you. And when I say magic language, I mean the everything language. Right? Margaret, how many times did we work on the everything language?
A lot, but it's perfect now and I have it.
Yeah, great, great. So you can email Margaret or you can email me. You can thank Lumber Products for, and now Stewart Building Materials for that magic language, because it is awesome. There's one last thing I want to say that you got to have in your credit application, and it's not in here, and you got to write it down somewhere. Okay, if you write it on your cover sheet, you got to write this one down. It's very important. Change of business form. Okay? Change of business form. I'm just going to read the language to you. Just going to say it. You guys write it down, and then if there are any questions. In the event customer changes its name or form, it agrees, it must notify seller's credit manager of such change in writing and by certified mail, return receipt requested. No other form of notification of change of business form is enforceable.
Can you repeat it?
Yeah, anybody who wrote that down, can you repeat it? Who wrote it down?
Only so requested.
John, you look like you wrote it down. Did you write it down?
I didn't get it all.
John Slamkowski wrote it down, I think. Did you?
Changes in the event customer changes its name or form, it agrees it must notify seller's credit manager of such change in writing by certified mail, return receipt requested. No other form of notification is enforceable.
Yep, and I'm going to let you say it into the microphone here. It's for our viewing audience. Go ahead and read that again. One last time? Yeah. Go ahead.
In the event customer changes its name or form, it agrees it must notify seller's credit manager of such change in writing, certified mail, return receipt requested. No other form of notification is enforceable.
Perfect. Any questions? Keep it simple, folks. That's the secret. And have good, healthy dialogue with your customer so you can see the problems coming. Okay? Maybe I'll see some of you tomorrow at our Lien and Bond seminars. I think we're doing liens in the morning and bonds in the second half of the morning. Thanks for coming.